You ready? Okay, Mr. McCarvey, you gonna sit in that first chair?
Yes, ma'am.
All the way on the end. Matthews is gonna sit next to Mr. McCarvey.
Shannon,
Hanka, you're gonna sit next to Miss Matthews. Miss Shannon, there's gonna be a seat between you and Miss Hanka. Andrews, you'll sit next to Miss Shannon. Miss Hardy, you'll sit next to Miss Andrews.
Weaver,
Mr. VZ, you're gonna sit in that first chair in the second, right there.
yeah, go ahead. Yeah, you have number 11 coming in, 10,
Right.
something right quick.
Right.
That's number 11.
Mr. Stigl,
Uh,
gonna sit in that chair that has the black and yellow tape on it. Bradley, you're gonna sit next to Mr. Stigl.
Right here?
Right here in the front. Miss Gidry, you're gonna sit next to Miss Bradley. Miss Trahan, you'll sit next to Miss Gidry. Miss Hawkins, you're gonna take that second row of seats and go all the way down to the end. And Mr. Veltz,
Yes, sir.
you're gonna follow Miss Hawkins and sit next to Miss Hawkins.
Ron,
Miss West, you're gonna follow Mr. Veltz and sit next to Mr. Veltz.
Thompson,
Mr. Vosberg, you'll sit next to Miss West, sit in the second row chairs. Thompson, you'll sit next to Mr. Vosberg, the second set of chairs. Smith, you'll sit next to Miss Thompson.
this is Mr. Weaver.
Mr. Weaver, come to the first row, right here, and you're gonna sit, there's a chair between you and Mr. VZ. Okay, that's it, everybody. Yeah, Miss,
What,
and
just let you not go to court for punishment.
You could-
Let them come up and let them know.
oh, no.
We avoid. I just not sure. Here.
You can hear better right there? Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. You have been called to come to court this afternoon for jury service. You've been called to have jury service in a criminal case. Now, you will be examined for inclusion on this jury hearing this criminal case. Our courtroom hours are normally from 9 a.m. to 5 p.m. However, in county court at law number 2, we usually have our dockets. Our dockets is just a list of cases. We have those cases in the morning between 9 a.m. to 12. Sometimes we go past 12. Now, whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected, the jury, if selected on the jury, unless otherwise instructed, you will be permitted to separate for recess, for meals, and at night. Now, before we go any further, I have an administrative matter that I must attend to, and I need each and every one of you to raise your right hand as I minister to you the first of 2 oaths. Will everyone please raise your right hand, and once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service qualifications as a juror, so help you God? Please say, "I do." Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you can serve or be considered for jury service. Also, there are certain excuses or exemptions that some of you may wish to claim. I will first determine whether or not you possess the qualifications to serve as a juror on this criminal case. If you do not, well, first of all, it's important that you answer the questions truthfully. If you do not answer the questions truthfully, and if the attorneys or I discover this matter after you are seated as a juror, you may be held in contempt of court. That is, you can be assessed a fine up to $500, and you can be placed in the Jefferson County Jail for up to 180 days. Now, I will ask you a series of questions. I do not want you to answer those questions out loud. Just answer the question to yourself. And then once I ask the final question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, I would ask that you will come up before the bench. This is the bench, so that we can discuss the matter more privately. Now, when I use the term more privately, what I'm talking about the fact that first of all, we are airing currently on YouTube. And then 2, I'll turn off the microphone so that you will not be able to hear me. And then 3, I have a noise sound device that I'll turn on so that the rest of the jurors cannot hear. The noise sound device sounds like this. Okay. So as I mentioned to you earlier, I will ask a series of questions. I do not want you to answer those questions out loud. Just answer the question to yourself. And when I finish asking the final question, I will then ask, is anyone disqualified under the law? If you think that you may be disqualified under the law, we'll ask that you raise your hand, and then we'll bring you up one at a time. First question. Except for failure to register, are you a qualified voter in the state of Texas and under the laws and constitution of the state of Texas, and are you a resident or qualified voter in Jefferson County? Have you ever been convicted of theft or any felony? Are you under the indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause before I ask this question, and I'm not trying to pry into your personal matters. I'm just required to ask this question by law. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? And this is the last question. Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the last question. Now, is there anyone on the panel who is disqualified under the law? Let the record reflect that no one on the panel is raising their hand. Now I will determine if anyone who is otherwise qualified to serve as a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous set of questions. That is, I will ask a series of questions. I do not want you to answer those questions out loud. Just answer the questions to yourself. And then once I finish asking the final question, I would ask if anyone would like to claim an exemption. First question. Are you over 75 years of age? Have you, do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving that child or children without adequate supervision? Are you a student in a public or private secondary school? Are you a person who is actually enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the state, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in Jefferson County during the past 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Now, this is the last question. Are you a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of your county of residence? Now, is there anyone on the panel who would like to claim an exemption? Let the record reflect that no one is raising their hand, so no one on the panel is claiming an exemption. Now I will move to excuses. And with the excuses, I'm not going to ask a series of questions. I will make 3 statements, and if any one of these statements apply to you and you desire to claim an excuse, once I finish making the last statement, I'll ask, is there anyone who would like to claim an excuse? And if you'd like to claim an excuse, you just raise your hand and then we will have you to come up to discuss that matter more privately. First statement. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse. No one is claiming an exemptions, and all members of the panel is qualified to serve as a juror in this case. Let the record reflect that the court is in session in cause number 24 CCCR 1826. The case is styled the state of Texas versus Logan Odebert. Let the record reflect that Mr. Odebert is present in court with his attorney, Attorney Ralph Kimler. Let the record also reflect that the state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, who's sitting first chair, and Attorney Andrew Hubel, who is sitting second chair.
Yes, ma'am.
Our court reporter sitting to my left is Mr. Sebastian Aguilar. He will be taking down everything that's being said, so speak up when you are answering or asking questions. The bailiff in the case is Miss Brenda Mosby. You met Miss Mosby earlier. The defendant stands charged by information with the Class B misdemeanor offense of driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to be fair, to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss the matter more privately. State, are you ready?
Yes, Your Honor, we are.
And defense, are you ready?
Ready.
Now, I didn't ask the state of nor the defense how much time. How much time do y'all need? What is 20 minutes, 30 minutes,
25 minutes.
25? That's fine. Is that fine with you, Mr. Kimler? Okay. Okay, so I'll be keeping the time. At this time, Ms. Nixon, you'll be doing the vote hour, is that correct?
Yes, Your
Okay, Ms. Nixon, the panel is yours and you may proceed.
Well, my name is Sarah Nixon. I'm Assistant District Attorney with the Jefferson County District Attorney's Office. I want to thank you for coming today. I appreciate your time. We need to take care of a couple of matters first before we go. Does anyone know myself? Sarah Nixon? Okay. Does anyone know the defendant, Mr. Logan Aldebert? Does anyone know Defense Counsel Ralph Kilmer? Sorry, Ralph Kilmer. Okay, no. Does anyone know the other, prosecutor, Andrew Hugel? No, don't know anyone? Does anyone know Judge or any of the other staff? Does anyone know anyone else in the jury pool? Anyone around, you know anyone? Give me 1 second, so it's. Is that Ms. Hawkins? Who do you know the jury pool?
Thompson, not well, but we do know each other.
Would your knowledge of each other interfere with any way in your decisions to be a jury?
I don't think so.
Being fair and impartial?
I don't believe so.
Okay. Okay. Okay, so what we're doing now is and what it is just simply to speak the truth. All we're gonna ask you today is be honest with your answers, just so that we can pick the best jury, for this trial. Jury selection is more of a jury B selection. It's just that we want to get the best as far as impartial and fair, make sure that people don't have biases or anything that'll hold them back from making an honest decision. Okay. So what we need to be able to do is examine the facts, apply the law to those facts, and follow the law. That's all we're asking. Today's case is gonna be a driving while intoxicated case. Does anyone have any been affected or know anyone who's affected by DWI? Anyone ever have your brothers, sisters, friends, cousins been affected by it? What was, sorry, I don't remember that. Okay, how's it, you're affected your DWI?
A family was hit by a truck driver, Lottie Mola, if you know,
I'm sorry,
Lottie Mola, if you know the name.
I'm not from around here, but I'm sorry. Is everyone okay? Did anything happen about it?
They're gone.
Was that recently?
3 years. In June.
Do you think that situation would keep you from being impartial and listening to the facts of the case?
Wrong.
Anyone else? Oh, sorry.
I had several friends in high school that worked out, and when I was, a physician and I worked at ERs and, seen some pretty awful things.
Would those experiences keep you from being fair and impartial and listening to those facts of the case?
I am pretty disgusted by it. Yeah, in my.
Me, my husband, and my two small, we were a baby at the time my son was born, and my daughter was a toddler. We had a collision with a drunk driver.
Everyone okay?
I was the only one that was hurt. The face was fine.
How long ago was that?
It was probably between.
Do you think that experience would keep you from being fair and impartial when seeing the facts of the case, be fair for yourself? Is there anyone else? Okay, thank you. Okay, so Texas Penal Code Section 4909. It is a perfectly commits an offense if the person is intoxicated while operating a motor vehicle in a public place. The elements the state will need to prove for this case will be So these elements will prove it was in Jefferson County, Texas. We have to prove the identity of the defendant. We have to prove about a certain date this happened. That it was during operation of a motor vehicle in a public place and while the defendant was intoxicated. Okay, as far as definitions, there is not a statutory definition of operate. Does anyone, what comes to mind when someone talks about operating a motor vehicle? Anyone have any? Driving? Anything else? Which one where it goes? Well, would you need to see operation? How far of an operation would you need to see in order to know someone's operating a motor vehicle? Let me ask, Ms. Hawkins, what would be operating a motor vehicle to you, and what would you need to show? What would we need to show for that?
Not sure I'm really understanding, but driving the
Yeah,
car,
driving car.
that you can tell that person is in control of that car, or whatever vehicle.
In control of the car? Okay.
I'm not sure I really fully understand.
It's just kind of, it's just as far as, because it's called driving while intoxicated, but it's kind of a misnomer because it's driving or operating a motor vehicle while intoxicated. So driving can be a part of it, and driving isn't necessarily. It's just driving or operating.
So it could be, so it could be stopped or something, is that what you mean? I don't know.
Well, that's why I was asking what your opinion of that as far
I
as
think if it's on and the person's in charge, that's
in charge, in the driver's seat kind of thing. It's on in the driver, okay. Thank you so much, I appreciate it. Okay. Anyone else have a different answer? As far as operating or driving? Okay. Next definition we have is a public place, any place is public or a substantial group of the public can go or have access to. So we go back to operation. So I talked to Ms. Hawkins and we were talking about that the car would be on and the person would be in control as far as if they were driving, if they were with the wheel. Okay. As far as showing operation, would it also be showing operation if someone were, if say, the officer was following someone, that they didn't catch up to them until they pulled into their drive? Would that still be considered operating or driving that vehicle? Does anyone think that would not be considered operating or driving the vehicle? Next thing is intoxication. You can't always tell when someone's intoxicated. But what would be some signs that you look for if someone's intoxicated or not? Can I ask this weekend? What are some signs of intoxication?
Walk straight line.
Walk straight line. Okay. Anything else come to mind?
I don't drink.
Okay. What about Miss Hardy?
Slurred speech.
Can't walk straight lines, slurred speech. Miss Hanka? Okay, what would you see if you saw someone? How would you think they would look if they were intoxicated? How do you think they would act?
Coordination, like the slur speech,
Mm-hmm.
incoherent speech, bad speech,
Okay.
belligerent.
And does intoxication necessarily require that they're drunk? Does anyone have an issue that someone could be actually intoxicated, but they wouldn't appear drunk to you? So say, like, normal people live it, but they don't necessarily look drunk to you. But that still counts as intoxication. Okay, does anyone have an issue with someone that could be intoxicated but not drunk? No? Mhm. Here's one. For intoxication, as an example is if you have a show of hand, how many people have been to a party and you think that someone who's getting in the car might not necessarily should be able to drive, or might not should be able to drive. Does anyone ever have that experience where you're at a party, do you see that happen? I was very sheltered life because I never went to parties when I was younger. I always had to work when I was older, so I never got around that. Okay, so the three bases for intoxication. There are three ways you can be intoxicated in the state of Texas. It can be that you're not having normal use of your mental faculties. For the indirection from the introduction of alcohol or other substance, or it could be the physical faculties, you're not in control of your physical faculties by reason of injection of alcohol or another substance, or having an alcohol concentration of 0.08 or higher. I always tell people that to look at it when you're looking at it, so the important thing here is the or. You don't have to, by the state of Texas, to be legally intoxicated. You don't have to have all three. You have to have at least one of those to be intoxicated. Okay, mental facilities, faculties, I don't like facilities. This is not having the normal use of your mental faculties by reason of introduction of alcohol, controlled substance, a drug, a dangerous drug, a combination of two or more substances, or any other substances. What does that look like when someone has lost their mental faculties? Can you help me with that? What comes to mind when you think someone has lost their mental faculties?
Not remember things or, actually,
Yeah, remembering things, reading things. And you're Mr. Beasy? Miss West? What is it when you think of someone who's lost their mental faculties?
Who's not able to perform normal activities or.
Yeah. Anything else come to mind? And I'm sorry I'm putting you on the spot, I'm just trying to get it in the room kind of thing.
I just, you're not able from your normal mental function and you're something, you're just, something's off.
So what's an important mental function whenever you're driving?
Being able to pay attention, stay between in your lane. Not swerving, you're not driving erratically, following the laws, traffic laws.
Does anyone else have anything to add to their mental facilities? Facilities, I see facilities. Okay, the next thing we can discuss is what it looks like when someone loses their physical faculties. This is still the not having normal use of your physical faculties by reason of injection of alcohol, or a controlled substance, a drug, a dangerous drug, a combination of two or more substances, or any other substance. Let's see. Miss Lisa? Tran? Is it Trahan? Trahan? What would you think of if someone asked, thought that what would you think of as far as what a physical faculty would look like if they lost control of it? Right, behavior? Okay. Okay. Angry. Miss Beatrice? What are some physical faculties you might see someone who's lost control? Stumbling. This last one is just kind of a numbers thing. If you have a blood alcohol content over 0.08 in the state of Texas, you are considered intoxicated. Okay. So after we've reviewed all these, So how many of these does the state have to prove? Does the state have to prove 1, 2, 3? 1, everyone says 1, can you raise your hand? Andrews, how many would the state need to prove for you to? This one? Okay, does anyone require that the state has proved by the last one in 0.08? Does anyone have to have the blood alcohol content to prove intoxication? No. Thank you.
Can we, back up to that one? Can you show that one again?
I'm sorry. Yeah, does anyone require that the state to show the blood or breath test results?
Are you talking about me requiring you to show them a piece of paper saying that the test was done?
That we would have to show you that it was done, that they had it over 0.08, or would one of the other, since we only have to prove 1, would 1 suffice, or is this the one that you need? As far as proof of intoxication.
Are they obligated to give a test, the person in the car?
My thing is, if somebody comes in here and says, hey, he was intoxicated. No, but now he says, we took him to the hospital, or we did a breath analysis thing, and here it is documented, then, you know.
Okay, but even if we could prove like he lost his mental facility faculties, if he lost his physical faculties, that wouldn't be enough for you.
No.
Would it not be enough for anyone else? You, Mr. Fosford?
Fosford.
Fosford. Okay, thank you, Mr. Fosford. Just remind you of the elements that we have to prove as a state. Is the county, the defendant's identity on or about a certain date, motor vehicle, they're operating a motor vehicle in a public place, and the defendant was intoxicated at the time. Okay, our burden of proof in this is going to be beyond a reasonable doubt. There is no legal definition of beyond a reasonable doubt. This is going to be where you come in with your common sense, your ability to reason, your logic, and your life experiences are going to all, you are the finders of fact, which means you are determining what is true. We're going to put evidence on, Mr. Kimmer might put evidence on, that you're going to determine what the truth is, and the burden lies with the state. We're the ones that need to prove the case or not. Okay. The court said that it doesn't mean beyond all doubt, it's just beyond reasonable doubt. You don't have to be absolutely certain that this is the truth, that it has to be beyond reasonable doubt. I believe this is what happened. Okay. Is there any questions as to the law surrounding WI? Okay, so what kind of evidence would you like to see in a DWI case? Mr. Weaver?
I guess that he was, doing a while operating the vehicle.
Okay, what would we need body cam footage, would we need testimony, what would you need?
Body game testimony, yeah.
Okay. How about Miss Thompson?
You have 5 minutes.
I would honestly love to see Mr. Terwood, but I would like to see documentation of the blood alcohol level potentially, and if that doesn't exist, then certainly I would have to see witness testimony, body cam footage, something that does prove that it's here.
Okay.
There was no suspicion.
Okay, so these are evidence examples, blood or breath tests, video, body worn camera, testimony by officers, eyewitnesses, and admissions made by the defendant. Okay, as far as witness credibility, we always need to wait till they speak. Witness credibility is in what they know and not who they are. And that's something I want to really stress. Sorry, we're kind of talking too much. If a witness is a peace officer, does their testimony have more or less weight than a non-officer's testimony? Does anyone have an idea on that one? Okay. What we need to see is that they're the exact same. You need to have that. You don't need to think that they're going to give you more of a story as far as their testimony doesn't carry any more weight than a regular person. Being an officer makes them special knowledge and examples of like SFTS. I already say that wrong. But in the legal matters, but in day to day, in what I've seen, this is what I saw, this is what I heard, this is what I smelled. They're be treated as any other witness. Okay. All right, I have a couple of questions. Okay, I have questions for Joe Stiegel. Sorry. Your brother is a K-9 officer.
Right.
Would you treat, does that make you more inclined to treat an officer's testimony with more weight than a regular person's?
No.
Okay, so you think it could be fair and impartial? Okay. And Miss West? Yeah. Your husband is a federal law enforcement officer. That being said, do you think that would make you give officers testimony more weight than a regular witness? Michael McCordy,
Yes.
you were on a criminal jury, remember, and y'all found a verdict. What kind of case were you in? What kind of case were you?
I don't recall those. So we had a case where it was basically a driving offense, and someone caused an accident, and I don't recall it was criminal.
Oh, we had it. I just saw it on your
Oh.
thing that said that, okay. I shouldn't ask, okay, well, thank you. With Daisy, said that you were on a criminal jury, what kind of crime was that for?
Child sexual.
You were forward, good. I'm good. We did Trehan, what kind of criminal jury were you? I'm sorry?
I'm sorry.
And Christopher Belts,
Yes.
oh, what kind of jury trial were you on?
It was a drug case.
A drug case? Is this like drug possession or manufacture? Okay, does anyone have a personal belief or religious belief that you can't sit in judgment of anyone else? You can't sit in judgment of another? Just remind me of what we need to prove. I did have more question for Ms. Hill, and that is Miss Matthews. Okay, you made a comment on the document about your husband's needs. Is that an issue? Are you primary care for him or? Okay, so. Okay, thank you guys for everything. Sorry, the panel, I appreciate your candor and I appreciate your honesty and talking to me, and I appreciate your time. Thank you very much.
24 minutes and 58 seconds. And Mr. Kimler, you may proceed. Yes, you may proceed.
Thank you, ladies and gentlemen. Drinking and driving, but you're nodding your head, yes, Ms. Austin.
Is it illegal?
Yeah, drinking and driving, drinking, consuming alcohol and operating motor vehicles, is that illegal?
In the car?
Operating vehicle, driving, sitting in it while the motors are on, is that illegal? If you consume alcohol?
Guess not if you're not.
Intoxicated.
Right, so what's the offense then, that we're talking about, the criminal violation that we're talking about today?
BW.
Intoxication, right?
Wow.
So you see the signs on the highway, I guess DPS puts them up, drink, drive, go to jail, is that accurate? Anybody, drink, drive, go to jail? Mr. Stigall, what do you think?
I think if you drink and drive and you're impaired, you should go to jail.
Intoxicated,
Intoxicated.
right?
Yeah,
So drinking and driving is legal.
If you drive drunk, go to jail.
Well, it's intoxicated, not drunk.
What's the difference?
Intoxicated is defined as not having normal use of your mental and physical faculties because of the introduction of alcohol, a drug, a dangerous drug, or a controlled substance, or a combination of those in your body, or having a blood alcohol concentration of 108 or above. That's how intoxication. So
While you're intoxicated, you should go.
after you've gone to trial and been convicted.
So
So drinking and driving is not illegal. Having alcohol, some alcohol in your system is not illegal while you're operating. Everybody on board, it's not. So like I said, when you see the sign that says drink, drive, go to jail, is that accurate, Ms. Heinke, is that accurate?
And you have your own personal blood
I'm-
alcohol meter?
I'm asking you, is it illegal to drink and drive and operate? No, it's they have some alcohol in your system and operate a motor vehicle, is that illegal?
Uh,
Ma'am,
I guess not,
okay, so.
that's what you're saying, yeah.
Well, it's not what I'm saying, I mean, you heard me, the definition of intoxication is this is driving while intoxicated, not driving while drinking while driving.
I'm not familiar with the law enough to answer that. I was not aware of that law.
The laws against intoxicated driving.
I was not aware that it was legal to sit in your car and drink an alcoholic beverage if your blood alcohol was less than.
Well, you can't sit in your car, and I guess if you're in your driveway, you probably could, but you can't have an open container in your vehicle, that's what you mean, that's a different offense, so. I'm talking about operating the vehicle. The standard is intoxicated driving, not having alcohol in your system and operating. So if you say you go out to dinner and you have a couple of beers or glasses of wine with your dinner, so you have alcohol in your system and you're driving home. And you're pulled over and you're not impaired, you have the normal use of your mental and physical faculties, you know there's alcohol in your system. Do you think that still should be an offense?
I never do that.
I didn't ask you that, man. Should that be an offense?
It's not.
I'm asking you, should that be an offense? You understand the purpose of my question?
I understand the purpose of your question.
What's the purpose of my question?
So the question is to define the law.
Purpose of my questioning is to identify particular people off this panel who wouldn't be particularly good jurors for my client in the DWI case. It's really a process of deselection, to be perfectly honest with you, where each side gets to eliminate 3 people off of the panel, for whatever reason they feel is necessary. And then the first 6 that aren't eliminated will constitute the jury, the theory being that they're acceptable on both sides and will be more likely to be fair and impartial. So that's the purpose of the question. Do you feel like this really is the type of case that you can be fair and impartial on?
To be honest, I don't think that.
Mr. Stegall, do you agree? You don't think you can be fair and impartial in this type of case?
Like I stated earlier, yeah, probably,
So,
probably not,
well, because you're opinion.
because of my personal experience.
No, not probably, because your opinion, not probably.
No.
And then, I guess, Ms. Matthews, on this subject, what about you? Do you think you can be fair and impartial? You've heard any question, Ms. Hanka, Mr. Stegall, same question. Can you be fair and impartial? You could be. I'm sorry, can you? Yes. Okay. All right. That's really pretty much the basic question in this case. You get this a lot of data, and I don't need to interrupt with either of you about your experiences. It is important that Mr. Overberg have a fair trial, and so I appreciate y'all's honesty and answering questions. It doesn't mean that you're not suitable for some other type of case. You want to show up on, if you end up being on a panel that has to do with theft, on a plethora of other cases that are tried and perfectly fine as yours. Just like if you just had your hard working into it where they're trying to murder them, it's the same thing. Whenever you walked in here and you saw Mr. Overberg sitting at the table, did you ask yourself, well, gee, I wonder what this guy did to be in trouble? Anybody? Sure, Mr. Weaver, what'd you think? Don, why'd you ask yourself? Just because he's sitting at the table and was a criminal? Did you think that he did something wrong? Illegal, I should say. Did you think that he has done something illegal at this point?
Yeah.
Oh, you thought they were the criminal? You're- Got my check box. I catch that impression. And had a guy in the front really raised his hand and said, no, I thought you were the defendant. The point is, he's presented me as a presumption of innocence. Now, does that mean factual innocence? I guess not so much on the DWI case, but other cases. There's legal innocence, right? And then there's factual innocence. Factual innocence means factually the person didn't do what they're charged with. Legal innocence means they're presumed to be innocent, irrespective of whatever the facts are. So there's that's the presumption of innocence. A lot of times you hear people conflate that to the person's actually innocent, then be innocent, I mean, they're factually innocent. Just like, if you remember OJ, so OJ factually innocent, or is he presumed innocent? He's found not guilty, not innocent, but the presumption of innocence adheres to any criminal defendant that's charged with an offense. The fact that the person is charged, whether it be an indictment, a felony, or be an information, or misdemeanor, isn't evidentiary, it doesn't carry evidentiary weight. It simply means that the county court judge in this case has the power to impanel a jury to hear evidence from the state to see if the jury would believe beyond a reasonable doubt somebody actually committed the offense beyond a reasonable doubt, so they'd be convicted. So he's presumed to be innocent. So if he voted right now guilty or not guilty, what would your vote be? Not guilty. Anybody that I don't know which would be guilty or not guilty? Anybody unsure? Votes not guilty. Why is that? Mr. Biggs, why is he not guilty? Right?
I haven't heard any evidence to say that.
Right. And he has the burden to convince you beyond a reasonable doubt that he's guilty. Who has that burden? Hey, all right. Proof beyond a reasonable doubt. Right. Does not guilty mean innocent? Right. Everybody get that? Does not guilty mean innocent? The juries find people innocent? Anybody? That's the juries find people innocent? Yes, ma'am. Do juries find people innocent? Yes. Who agrees with Ms. Guidry? Juries, okay, Ms. West, your husband's federal law enforcement?
Innocent, but just not guilty.
Is it the same thing?
Well, maybe they are guilty, but it wasn't proven without a reasonable doubt. So
Oh,
the jury could say they're not guilty because maybe the state didn't prove its case.
does that mean innocent? Does that mean factually innocent? Does it not guilty mean factually innocent?
Well, maybe they were innocent, maybe they weren't.
What?
Innocent.
Well, I know you're overthinking this. Does not guilty mean factually innocent? If a person factually didn't do what the state's alleging?
So, right.
What's that?
Maybe the state couldn't prove it, like maybe he was and maybe he wasn't, but the state doesn't prove it.
What does not guilty mean then? Mr. Lee's, you gonna help her out?
Please help me.
I'm sorry, Ms. Mossberg, you gonna help her out?
They didn't prove the point, he might have been drunk, but he wasn't intoxicated.
Let's say murder, right? Let's just make it something else. Let's say murder.
Did commit the murder, but
Right.
if the state doesn't prove it, the jury can say
Not guilty.
not guilty.
So does that mean he's innocent? That he didn't do it? That he actually didn't kill the
No,
person?
he still could have done
Yeah,
it.
so does not guilty mean innocent?
No,
No, not guilty, but not guilty does not mean innocent.
right,
Okay, right? Not guilty means there's a reasonable doubt. They haven't eliminated every reasonable doubt that you might have about the case. Person could still be, they had the rights
sure,
that they did. They're just not guilty because they can't prove it. It's just like,
absolutely.
you have somebody here as a defense lawyer, how do you represent guilty people? I don't represent anybody. Every person I represent is not guilty. Until a jury says, I don't represent guilty people, right? He's not guilty, right? So do I represent a guilty person right now? No. You gonna make it convicted? It's a legal concept. Guilt and not guilt is a legal concept. Innocence an actual, that they actually did it, that's really, you would think that it would be legal, but it's not, right? Or people been convicted, found guilty beyond a reasonable doubt, and later on, it's been found out that they actually didn't do what they were convicted. All right? What circumstance have you heard? Corey, you've been kind of quiet, give me an example of that.
There's been plenty of plenty of cases.
Project, yeah.
Projects, yeah.
Like DNA, right?
Yes.
All the time, sure. Somebody gets convicted, DNA comes back, wasn't him. So we're not talking about certainty for a conviction, certainty. Guilty is not certainty, it's beyond a reasonable doubt, doesn't mean certainty, not 100%, you aren't there, you don't know. And there's no definition of what that standard is, Judge Holmes is gonna give you, there's no definition that you're gonna have, each of you are gonna have to come up with your own idea of what level of proof, what level you're gonna acquire the state before you can say it's beyond a reasonable doubt. So, all right, you're looking at me very quizzically, yeah, but does that sound?
It sounds perfectly correct, and I'm
Yes, ma'am. So you think that the state, since it's such an important concept, decided that idea of proof beyond a reasonable doubt, that they would give you a definition, that Judge Holmes would tell you what that is?
hopefully.
Well, he's not. You're gonna have to come up with that on your own. What do you think it is?
I think that in my heart and in my mind that they will need to prove to me that this young man did something that he shouldn't have been doing.
How high of a standard? Is it kind of probably, or is it something normal?
No, I think it's a high standard
Why is it a high standard?
because I think that there are times and instances that people are charged with stuff that they shouldn't be.
Okay, that they're actually innocent.
Correct.
Sure. So you want to have a high standard, require the state to have a high standard to avoid wrongful conviction.
Correct.
What's the result of finding somebody guilty?
Oh, it ruins their life.
Well, I mean, it's maybe in some cases, but what's just more in a general sense? What's the result, just practically speaking, of finding somebody guilty? What happens if you're found guilty? One word.
You go to jail.
Well, what's going to jail? Punishment, right?
Yes.
Okay. So that's how we decide whether or not in our system, whether somebody's to be punished for something. Is this idea of proving the case beyond a reason. So if you find somebody guilty, you find that they should be punished. Do you think the idea of this punishment, that somebody could lose their freedom, should sort of maybe set the parameters, or maybe frame the idea of proof beyond a reasonable doubt? That what we're talking about is a standard before somebody can be deprived. How high of a standard we want to put before somebody can be deprived of their freedom?
Yes.
Does that make sense to everybody? Miss Hawkins, what do you think? Yeah, what do you think? You agree with Miss Hardy that it's a high standard of proof? Why do you think it? Why should
Freedom, pretty much.
pretty important, right?
For any of us, for any number of reasons.
Mr. What do you think, Miss Thompson? I'll have a standard of proof.
Um. Wrongful conviction for anything.
Sure, okay. What about you, Mr. Smith? What do you think? Sure, and you want to be on the jury or? Sure. We're kind of in the back, that's how it works, the farther to the back, the less likely.
I was debating whether the more you talk or not.
Yeah, well, I said I wouldn't go 25 minutes, how much time I got left?
11 minutes.
All right, I'll go about another minute, I'll give you. All right, anybody have any questions of me? No? All right, I mean, all of you sit down. Everybody? Yes, all right. After asking Ms. West, where her husband?
Everywhere.
Yeah, oh, VOP? That's not really law. Where is he in the IG office, or what's he do up there?
Case management.
So he's more of a, like a case manager. All right, thanks.
Okay. Okay, ladies and gentlemen, at this time, we're going to ask that you go out into the hallway. You can go out either door. We may have to call some of you back in for some follow-up questions. So at this time, would you please stand and exit the courtroom? Gonna be in recess. Okay, hold on a minute.
3:11.
Hold on a minute. Jefferson County Court Law number 2 is back in session. The court is in session in cause number 24 CCCR 1826. Case is filed in the state of Texas versus Logan Oderbert. Let the record reflect that Mr. Oderbert is present in court with his attorney, Attorney Ryan Kimler. Let the record also reflect that state is present with Assistant Criminal District Attorneys, Attorney Farrah Nixon, who's sitting first chair, and Attorney Andrew Hubel, who is sitting second chair. Let the record also reflect that the jury panel is now present and seated in the courtroom. Ladies and gentlemen of the panel, when your name is called, we're going to ask that you go to the jury box. There are some tags right there on the countertop. You can get a tag and pin it to your clothing. We have one of our court coordinators, Ms. Trina Redmond. She will be calling off the names. And if your name is called, please go to the jury box, get a tag, and have a seat anywhere in the jury box. Okay? Ms. Redmond, you may proceed.
Judy Hardy.
Judy Hardy. Shoulder.
Cliff Easy. Thelma Guidry. Letha Trahan. Amy Hawkins. Christopher Phipps. Nikki West.
You can pin the tags on. Okay, ladies and gentlemen of the jury, at this time, I must administer to you the second of the two oaths that I previously mentioned earlier. Now, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say I do. Do each of you do solemnly swear or affirm that in the case of the state of Texas versus Logan Oderbert, that you will a true verdict render according to the law and the evidence, so help you God? You may say I do. Okay, you may put your hands down. Ladies and gentlemen of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witness stand, and the law comes from the statutes, codes, rules, and other decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts and I'm the sole judge of the law. You're the sole judges of the credibility of witnesses and the weight to be given their testimonies. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that we can discuss the matter outside of your presence. The reason for this, as I told you earlier, you're the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather his equipment and take it with him. And the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defense have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The state have the right to make a summation, the attorneys have a right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or on social media, or watch television reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you'll be allowed to take those badges home with you. And please wear those badges when you come back to court, because the badges identify you as a juror in this case. Now, ladies and gentlemen of the panel, those of you who are not selected to serve as a juror in this case, first of all, I'd like to thank you for your time and attention, for showing up here this afternoon. I know some of you may be disappointed because you had the intentions of sitting or serving on this jury. However, there are only so many people that we can put on the jury. And some of you might think that, you know what, I came here this afternoon to serve on the jury. I wasn't selected, so I just wasted my time. Well, you did not waste your time. And the reason why you didn't waste your time is because, as I mentioned to the panel earlier, our courtroom hours were normally 9 a.m. to 5 p.m. However, in the morning time, we have several cases. We have dockets. We have what we call And the docket is just like a list of cases that we have. We have a jury trial docket, we have a pretrial conference docket, and we have an announcement docket. So we have several cases, somewhere in the neighborhood of 50 plus cases that we went through this morning. And some of those cases was cases that they were disposed of. And the reason why when I say disposed of, people pled guilty, cases got dismissed, etc. Now, the reason why sometimes we have trials for some people, well, first of all, each person who has a criminal case has a right to have a jury trial. And before they even get to the jury trial, they normally have an attorney that's appointed. If they represent themselves, they act as their own attorney, and the state meet with the defense attorney or with the person who's representing themselves and give them an offer to settle the case. We call that a plea bargain. Okay, and sometimes we come to an agreement, sometimes they don't. They do not come to an agreement. In essence, state can make an offer, they can reject, or they can accept the offer. You know, sometimes some people reject the offers because they might think that, you know what, one or two things is going to happen. One, the jury's not going to show up on the day of trial, or the witness is not going to show up on the day of trial. But on days like today, when they're informed that we have a jury that's going to show up, it is not uncommon for some people to say, you know what, that offer that the state made to me a few months ago, it looks pretty good right now. And so it's because of individuals like you who took time out from your busy schedules to come here, we were able to move cases. We cannot move cases without jurors who show up to court for jury service. And so on behalf of the citizens of Jefferson County, behalf of staff here in County Court at Law Number 2, I'd like to thank you for being here today, and so you did not waste your time. I know that when you came here this afternoon, you looked over the top of the door and you saw the sign that says County Court at Law Number 2, Judge Terrence L. Holmes, and you probably said to yourself, oh, this is Judge Holmes' court, I'm in the right place. Well, this is not Judge Holmes' courtroom. This courtroom is for the citizens of Jefferson County. And so I'm only an humble public servant serving the citizens of Jefferson County. And so I've said that to say this. Anytime that you're in the area of County Court at Law Number 2, you can have a seat in your courtroom. Now you can sit in that area that you're sitting in. We call that the peanut gallery. But it doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat and see what goes on in your courtroom. Now, if you cannot come to the courtroom on a day, you can watch us on YouTube. We're on YouTube 5 days a week, okay? And you can see what goes on in Jefferson County, and I'm sure you'll find it very interesting. Now, your jury service is concluded. If you need excuses, we have the district clerk's office, which is right across the hall. They can provide you with an excuse. Our bailiff, she has some letters that she's going to give to each and every one of you, thanking you for being here today. If you'd like to drop a line, please feel free to do so. But before you go, I usually give the jurors a handshake, but as I tell people, we still have COVID and in our community, so I can't give you a physical handshake, but I can give you what I call an air handshake. So on behalf of the citizens here in Jefferson County, he gave a fist bump, an air fist bump. That's a new one. And so you're free to go, and y'all have a blessed day. You could go out either door. And the bailiff has letters for each and every one of you. Now, ladies and gentlemen of the jury, I've been informed by the state that this case is going to start up tomorrow. And I'll just give you a little heads up as to what's going to happen. It's going to start off with us reading the charging instrument. In the misdemeanor court, we call it an information. In the felony court, they call it an indictment. It's just a charging instrument, okay? That's going to be read. Offender's going to enter his plea to it. and depending on what is split, we will go to, opening statements. The state will make an opening statement, the defense can make one or they can reserve it. And then after opening statements, then we'll start off with the state's case in chief. That means they'll be calling their first witness and the trial will proceed from there. Okay, so that's what we can expect in the morning. I mean, tomorrow, and we're gonna have you here at 1:30. Okay, make sure that you're here on time. Have a seat right there in front of the courtroom, and when we're ready, the bailiff is going to come and get you. Okay, so you'll be free to go. We'll be in the court will be in recess at this time. Jurors, you can stand exit the courtroom. Everyone, please stand as the jury exit the courtroom.
Whenever they go in. Or the judge.
Sir, it'll be finished by 5 each day.
That's the goal.
Okay.
Not necessarily.
We'll
That's
see.
all, ma'am.
Sometimes,
Thank you.
I disagree, we don't always finish.
Yeah, I mean, yeah, we'll see.
About, just,
Yeah.
thank you. So weird question.
And this court method is weird.
And I can teach tomorrow half a day and be here at 1:30?
As long as you have 1:30.
Yes.
Okay.
Yeah,
Sorry, that was.
Okay.
Okay, she needs to.
okay.
Thank you.
Court will be in recess.
Like, be back on 15.